Hey everyone, this side Akshay Kaushik. I am a Delhi-based practicing lawyer. Today I'm going to talk about the ex parte order and the contested order. I know that most of you might be knowing about these two orders if you are a law student or a law intern or if you are a lawyer itself. But still, I want to make this video because recently, just few days back, I was having a discussion with one of my client, and also my intern was also part of it, and they both were trying to convey to me that, sir, as the opposite party is not coming before the court, we have the absolute right. We can push the judge now to get the ex parte order, and if we get the ex parte order, then we will be in a situation to execute the same. But on the contrary, I had to convey to them that yes, ex parte order is the good order, but according to me, ex parte order is not the best order. I feel personally that the contested order is always the better order if you get from the court. So in this particular video, I would like to convey the same point to you as well, that why according to me ex parte order is not the best order and why the contested order is always the better order as compared to ex parte. So before getting into the differences, before getting into the favorable order, I would like to give you a brief about a bit of the both the orders, like the ex parte and the contested order. Ex parte order means the one-sided order. For example, if you file a suit, firstly let me tell you that ex parte order is always in civil proceedings. It has nothing to do with the criminal proceedings. If you have filed a civil suit in the court and opposite party does not appear, then the court has the power to pass the ex parte order in favor of the plaintiff. And after you get the ex parte order, the evidence of yours will be done by the court itself, and after reading the evidence, the court will pass the judgment in plaintiff's favor. That is basically the ex parte order, which means there is nothing related to the cross examinations from either side, and there is nothing related to framing. Obviously issues will be framed, but there is nothing related to the arguments in the court will straight away pass the judgment. The trial procedure will not be there in the case of ex parte order. While on the other hand, if you go for the contested order, the opposite party will come before the court, they will file their written statement, you will file the replication, again they will have the right to file their rejoinder itself. After that, the issues will be framed by the court, and after framing of issues, the cross examinations will be done, like defendant will cross examine the plaintiff and plaintiff will cross examine the defendant. After the conclusion of cross examination, the arguments will be done. There will be multiple miscellaneous applications will be filed in between the course of the trial in civil proceedings. It could be like 711, 617, so many applications can be filed by the either party, and after that the judgment will be passed. That is a contested case which you contest, in which you face all the trial. But in the case of the ex parte order, there is no such trial. There is just a one-sided order in favor of the plaintiff and against the defendant. But now you might be thinking that you do not have to face the trial in the ex parte order. So why I am appreciating the contested order? Also the contested order is taking so much time of yours. Now why I am conveying on the point of contested order is, reason behind it is that if you get the ex parte order from the court, there are chances that the opposite party, and according to me there are 100% chances that opposite party, after 2 or 3 days of lapse of the court hearing, they will come before the court and he will file the application of setting aside the ex parte order, stating his reasons of his non-appearance. He will give any false reason whatsoever that I did not appear before the court because of such and such reason. And if the court passes the ex parte order and continuing in executing the ex parte order, it will prejudice to the rights of the defendant. And because of such reason, if court finds out that particular reasoning of the defendant satisfactory, court has the right to set aside the ex parte order, which means you have waited for almost 6 months, 7 months or 8 months or 1 year down the line. After that, the defendant will appear before the court. He will state any false reason before the court, and he will get the ex parte order set aside. So which means after setting aside of ex parte order, you will again have to go through the miscellaneous applications, the cross examinations will be done, the evidences will be laid by both the parties, and then the judgment will be passed, which means you have somehow unintentionally wasted your time. So that is the reason why I had to convey to my associate and also to my client that we will not gonna push the judge for the ex parte order, because only 2 dates have been passed. We will still wait for the opposite party to come before the court to file their WS. At most, what you can do, if the opposite party is intentionally, or you can say deliberately delaying the matter, they are not coming up before the court, you can ask the court, you can approach the court for imposition of heavy cost upon them. Apart from that, you can also approach the court for striking off the defense of the defendant, which means they will not be able to cross-examine you in the court and they will not be able to lead any evidence. So that you can do, but pushing the judge for the ex parte order in 2 or 3 days, that is not a favorable choice according to me. I also want to take your opinion as well. What are your views upon it?